details, but thank you everyone for joining us this morning. Thank you, Jose, for reaching out for us to do this presentation. With us, we have our Chief Marketing and Communications Officer, Jessica Vargas, and our Deputy General Counsel, Michael Cesar. I hope I said that right, Michael. You could correct me because I don't get.
It's Caesar. Don't worry about it.
Caesar. Okay.
You were still close.
I wanted to pronounce it like Caesar, like, you know, A2 Brute, but, you know, I didn't want to give you like, you know, inflate your ego anymore because, you know, it's so ginormous. But anyway, okay. So Jessica will be presenting, going through a slideshow to present. And I know that usually the Q&A portion enables people to ask questions that arise. I know sometimes there's some very specific things, and that's why having Michael on is hugely helpful because he's a rock star at that. Jessica's a rock star at presenting, so we're lucky. The best of paid leave authority here today. So I am I'm gonna let Jessica get to it. So go ahead.
Great, thank you, Jacqueline. Thanks everyone for joining this morning. Pleasure to be here with you all. I will share my screen. And we will get going. I'll put it in slideshow mode. All right, great. All right, so we are going to talk about everything you need to know about Connecticut Paid Leave today. Quick introduction to the Connecticut Paid Leave Authority. We are a quasi-public state agency, and our mission is to provide pathways to accessible paid family and medical leave benefits and to empower everyone who's affected by the program with tools to navigate and understand their role within the program. Now, we always start this presentation by going into a little bit of the difference between FMLA and Connecticut Paid Leave. The reason we start by talking about this is that FMLA and Connecticut Paid Leave are two separate laws. They're closely intertwined, but they do provide different things. And it's very important to understand that one that they do operate separately as two separate statutes. So FMLA, which you may be familiar with, is the Family and Medical Leave Act. And FMLA has been around both on the federal and the state level since the 1990s. What FMLA does is provide job protection when an employee takes time away from work for a qualifying family or health reason. However, the leave taken under FMLA has always been unpaid. So some employers will provide income replacement. For example, they might provide a certain number of weeks of maternity or parental leave, or they might allow their employees to use their PTO accruals, but that's not a requirement of the law. The only requirement is that the person is able to have their same job back when they return from leave with the same terms and conditions. Connecticut's FMLA law did change pretty significantly on January 1st, 2022. Now, Connecticut Paid Leave is the statute that provides for income replacement when someone is taking leave for an FMLA qualifying reason. But Connecticut Paid Leave in and of itself does not provide job protection. So I like to think of it as the two opposite sides of a coin. You have FMLA on one side with job protection, but no income replacement. And then you have Connecticut Paid Leave on the other side, providing that income replacement, but not the job protection. And that's why it's really important when someone is taking leave, if they are in fact eligible for Connecticut Paid Leave, that they do also speak to their employer about FMLA, because it's great to have the income replacement, but we want to make sure that they also are entitled to have their job back when they return. So what are the qualifying reasons for leave? Now, these are the qualifying reasons both for job protection under FMLA and for income replacement under Connecticut Paid Leave. There are 6 reasons. There's medical leave, which is leave that a worker would take for their own serious health condition to receive treatment for or recover from. And this does include serving as an organ or a bone marrow donor, and it also includes pregnancy, including the time that's needed for prenatal appointments. The second type of leave is bonding leave. That's leave that a worker would take to bond with a new child that's entering their home either through birth, adoption, or foster care. It is available for both mothers and fathers, and it can be taken at any time during the 12 months after the child's birth or placement in the home. In the case of adoption or foster care, bonding leave can also be used for pre-placement activities. The third type of leave is caregiver leave. That's leave that a worker would take to provide care or comfort for a family member who's experiencing a serious health condition. And Connecticut does have a very expansive definition of family, and we're going to talk about who that encompasses in just a moment. The next two types of leave apply to the military. There's military caregiver leave, which is caregiver leave, but for a worker to take for a covered service member who was injured during federal active duty. And then there's something called qualifying exigency leave. Qualifying exigency leave is leave that a worker can take if their spouse, child, or parent is notified of an impending call to federal active duty in the armed forces. So when someone is called to duty, there may be certain things that the worker needs to take care of before that family member or spouse or child goes away. So it could be doing some banking, it could be seeing their attorney to do their will, it could be making alternative childcare arrangements. So there are several different things that could fall under qualifying exigency. And then lastly, Connecticut does have a Family Violence Leave Act. And a victim of family violence can take up to 12 days in a calendar year to seek medical or psychological care, to obtain services from a victim services organization, to relocate, or to participate in court proceedings arising from the family violence. So those are the 6 reasons for leave for both job protection and for Connecticut paid leave benefits. Now, for several of those, you did hear me mention a serious health condition. So there is a statutory definition of what constitutes a serious health condition. And we feel like it's important to go through this because we just want it to be very clear that this is not leave for your kind of run-of-the-mill illnesses. For example, you know, you have the flu, you might feel pretty crummy, you might have to stay home from work for a couple of days. But if it's not falling into one of these criteria that I'm about to go through, it wouldn't be a qualifying reason. So what constitutes a serious health condition? First, the person perhaps has an overnight stay in a hospital or another medical care facility. That would make a serious health condition. The second would be if the person is incapacitated for more than 3 full days and they seek treatment from a healthcare provider within the first 7 days. That healthcare provider requires them to have continuing treatment, perhaps there's prescription medication, or they advise them to come back and follow up within 30 days. The third criteria would be a period of incapacity due to a chronic condition for which the person sees their healthcare provider at least 2 times per year. Next would be a permanent or long-term condition for which treatment is no longer effective. This might be something like the terminal stages of cancer or Alzheimer's. Next would be restorative surgery after an accident or injury, where if the person did not have that treatment or that surgery, they would be incapacitated for more than 3 days. So an example could be a surgery for a broken leg. And then lastly, as I mentioned previously, pregnancy is a serious health condition that does include time for prenatal appointments, and a person who's experiencing incapacitation during their pregnancy may also qualify for a bit of additional time on top of the normal 12 weeks. And we will get into more detail about the length of time that's available. Now, when we talk about caregiver leave, as I mentioned, Connecticut has a pretty expansive definition of family. So the primary difference between federal laws and Connecticut's laws, and when I say Connecticut's laws, I mean both Connecticut's FMLA and Connecticut paid leave, is really who constitutes a family member. So under federal FMLA, an employee can only take leave to care for a parent, a spouse, a child under 18, or a child over 18 who has a disability. Those are the only familial relationships that are recognized under the federal law. Under Connecticut's laws, the relationships that are recognized as family are the ones you see listed on the slide. That includes a parent, a spouse, a child of any age, a sibling, a grandparent, a grandchild, or an individual related to the employee by blood or affinity. So what on earth does that mean, related by affinity? It means that if the worker has a significant personal bond that is like one of those family relationships listed, that person can be considered family, regardless of if there's any biological or legal relationship. So this is obviously situation specific. It depends on the individuals involved. But to give you a couple of examples of what this might look like.
Because they're family.
Yeah.
Let's say, for example, you have an aunt or an uncle who relies on the worker for unpaid care, and they maintain a relationship that's typical of what you might see between a parent and their child. That could be considered related by affinity. Another example might be an unmarried couple. So the worker's significant other, they have a family-like, spouse-like relationship, but they are not legally married. So therefore, they don't have a legal relationship to each other. That would also be related by affinity. These are some of the basics, but what else do you need to know about Connecticut paid leave more specifically? Here is who is currently covered by Connecticut paid leave. Most employers in Connecticut who have one or more people working in the state are covered, and non-unionized state of Connecticut employees are covered. Right now, the federal government is not a covered employer. Municipalities and local or regional boards of ed are not automatically covered, but their unionized employees can collectively bargain for participation. Non-public elementary and secondary schools are excluded, as are railroads, the governments of other states, and sovereign nations. A couple of other exceptions are interstate truck drivers who might work in Connecticut, but they live in another state and therefore they don't pay taxes here. And then spouses of active duty military who continue to pay taxes in their home state. Now, if someone does work for a covered employer, what makes them eligible for Connecticut paid leave benefits? There are two different criteria. The first is a minimum earnings criteria. So the worker must have earned at least $2,325 in the highest earning quarter of the first 4 of the 5 most recently completed quarters. To sort of help visualize this, we have this chart on the slide. So if we're looking at example for claims that are being made for this second quarter of the year, April, May, or June, we would be looking back at the quarters that you see in green to see if this minimum earnings criteria has been met. So we'd essentially be looking back at quarters 1, 2, 3, and 4 of 2021. However, quarter 1 of 2022, so the 5th quarter, if you will, would not count, would not be one of those qualifying quarters. In our example, you can see that our hypothetical worker did in fact earn the 2325 in Q2 of 2021. Therefore, they would be able to check this box. This amount of money can come from one or more covered employers in Connecticut. So individuals who are perhaps part-time workers, as long as their combined earnings from their covered employers meets or exceeds that 2325, they would qualify under this criteria. The second thing is that they have to either be currently employed in Connecticut by a covered employer, or if they're not currently employed, they were employed by a covered employer in the 12 weeks immediately before their claim for benefits. Additionally, just as a side note, sole proprietors and self-employed individuals can opt into this program, even though they are not required by statute to do so. But if they do opt in, they have to have been contributing to the plan for at least 91 days before they can file a claim for benefits. Now, we share this information for your awareness, but this is not something the employer has to make a determination on. The Connecticut Paid Leave Authority makes the eligibility determination by using data from various state agencies to review wages. Next important question is, what kind of benefits will people receive? So workers who earn minimum wage receive 95% of their base weekly earnings. For example, if you have a worker who works 40 hours a week at the minimum wage of $13 an hour, they're earning $520 a week. They would be eligible for 95% of that, or $494 per week. That's a pretty straightforward calculation. Workers who earn above minimum wage have a different benefit calculation. I am not going to try to explain it because it's super complicated, but if you would like to torture Michael, I'm sure he'd be happy to explain it. But the important thing to know is that in all cases, benefits are capped at 60 times the minimum wage. And that works out right now to be $780 per week. Now, we do have a benefits estimator on our website. You can see a screenshot in the lower left corner, and this is a great tool if someone is interested to see what they could potentially be eligible for. You just go in, you put your pay period frequency and your gross earnings, and then you can see an estimation of what you could potentially receive. Eligible workers can receive up to 12 weeks of income replacement in a 12-month period for almost all reasons, including military caregiver leave. The exceptions are that only 12 days of the 12 weeks can be used for family violence leave. And an employee who experiences incapacitation during their pregnancy may receive 2 additional weeks, so potentially up to 14 weeks in that circumstance. Now, I want to talk a bit about FMLA just to, again, sort of illustrate the differences between the two laws. In order to be covered under FMLA on the federal level, an employer must have 50 or more employees within a 75-mile radius, and government entities of any size are covered under federal FMLA. Under Connecticut FMLA, this is one of the recent changes that just went into effect in January. Almost all employers who have 1 or more people working in the state of Connecticut are now covered. All state of Connecticut employees are covered. You can see the list down there on the right of those entities that are not covered currently under Connecticut FMLA, and they are the same entities that are not covered right now under Connecticut paid leave. Now, what about eligibility for job protection under FMLA? On the federal side, someone must have worked for at least 12 months and at least 1,250 hours in order to have job protection. Under Connecticut FMLA, again, another major change that just went into effect a few months ago. Job protection is available after 3 months of employment, and there is no longer any hours worked requirement. One of the main differences between FMLA and Connecticut paid leave is that FMLA is a discussion between the employee and the employer. So the employer has to make those eligibility determinations for FMLA for job protection. But with Connecticut paid leave, the individual is applying directly to us at the paid leave authority, and we are making the determinations as they're looking. Again, job protection under FMLA, both on the federal and the state side, up to 12 weeks in a 12-month period, up to 26 weeks in a 12-month period for military caregiver leave. So I will just point out that under Connecticut FMLA, there's up to 26 weeks of job protection for military caregiver leave, but only 12 of those weeks are payable under Connecticut paid leave. Again, potentially an employee could receive 2 additional weeks for incapacitation during pregnancy, as I mentioned on the paid leave side as well. And for family violence, there's also up to 12 days of job protection in a calendar year available under the Connecticut Family Violence Leave Act. Let's talk about the process of applying for paid leave benefits and what that looks like. There are 2 different ways to apply for paid leave benefits. The way that we prefer, because it is the fastest and easiest and gives the applicant the most control, is through the website, ctpaidleave.org. We work with AFLAC as our third-party benefits administrator. So applications are also accepted via telephone at the 877 number that you see. We do tell individuals that even though they are applying directly to us for benefits, they do need to notify their employer that they are applying. And this is also, of course, the right time for them to talk to their employer about FMLA for job protection. So the worker starts their claim by either calling AFLAC or logging into our website to submit their claim. AFLAC will tell them what kind of documentation they need to submit and by what date they need to submit it. The documentation will be different based on the type of leave they're taking. So if it's for their own health condition, they'll need a medical certification from their doctor. If it's for bonding because they've adopted a child, it might be their adoption documents. If it's something military related, it might be a copy of military orders. So AFLAC will let them know what they need to provide. AFLAC will determine their eligibility for benefits so that they've met that minimum earnings and that they are applying for a qualifying reason. They'll then review all the documentation and either approve or deny the claim as appropriate. We'll calculate the benefits and issue the benefits to the individual weekly, either through direct deposit or on what's called a stored value card, which is a prepaid Visa debit card. The worker is to notify AFLAC of any changes. So for example, they need an extension or they're able to return to work early, etc. Even when someone is approved for FMLA, the employee does have to follow their employer's, attendance and call-in policies and notify their supervisor when they're taking leave. The employee does have to notify their employer and the authority and give us complete and sufficient medical certifications and other documents. And we do always want to advise that there might be other laws beyond FMLA that can provide for job protection. Lastly, let's take a look at roles and responsibilities. So for Connecticut paid leave claims, there's 4 separate buckets of responsibility. The majority of the responsibilities are on the worker. So the worker has to submit their application in a timely fashion. What we mean by that is 30 days in advance if the leave is foreseeable, and as soon as practicable if it's an emergency or an unplanned leave. Excuse me, the worker is to provide all the supporting documentation and of course update their account with absence information, other potential sources of income, and notify their employer that they have filed a Connecticut paid leave claim. Excuse me. On the employer side, there's not a terribly lot of work that we need the employer to do. We tried to make this as turnkey for the employer as possible. There is one document that the employee would provide to their employer. It's called the employment verification form. The employer would fill that out. And beyond that, they should just notify their employee about their PTO policies and short-term disability policies and refrain from any discrimination or retaliation. As I mentioned, the Connecticut Paid Leave Authority works with AFLAC, and we will do all the determination of availability, reviewing the documents, calculating the benefits, monitoring the claims, investigating any potential fraud. The Connecticut Department of Labor comes into play because they will investigate any appeals related to the denial of claims. We do offer a reconsideration process where we will look at someone's claim again and see if a different decision should be made. And the reason someone might do that is perhaps they missed the deadline to provide all their documentation, but they now have it, for example. But if someone doesn't wish to do that, or if they do that and they are again denied, they can go to the Connecticut Department of Labor and file an appeal. A couple of additional resources for you to be aware of. Our website has a lot of information about the program, ctpaidleave.org. While we don't have a call-in number, we do have a contact us portal on the website. And when you submit a question, one of our contact specialists will get back to you within 2 days, and they can call you if you would prefer to talk to someone instead of emailing back and forth. And then for questions about already filed claims, we always advise people go directly to AFLAC for that. Any questions on the job protected piece for Connecticut FMLA would be directed to the Department of Labor. And that long web address that you see is a new dedicated landing page that they have put all the new guidance for Connecticut FMLA. We also have downloadable resources on our website that go into everything I've talked about in more detail. So we have resources for employers, for human resources, individuals, and tons for employees. We also have many videos on our YouTube page that go into more detail about a lot of the different aspects of the program. And with that, I will stop sharing and open it up for questions for Michael.
Hello, everybody. I think if people just want to shout out questions, they can. If they want to raise hands, if we have a lot of questions, we can do that as well. I think there's an option to raise your hand somewhere at the bottom under the reactions feature. Andrea, it looks like your hand's raised.
Hi.
Hello.
I have a couple of questions. So is there any proof that's required for a relationship of affinity? Like, so if you were to say, you know, this is my unmarried partner, do you have to provide like joint bank statements, or is there any kind of proof required?
So generally, all we ask for is a brief statement of the relationship. There's a form, but it basically has a blank for you to fill in any details you want to on how this relationship may be like a relationship more official relationship that's covered. It's possible we may ask for more, but generally we wouldn't. If you certify to us that this person is my neighbor, but they're like a brother to me and they go to all my holiday events and things like that, we would accept it. We rarely would require any other official documentation beyond that statement to prove that.
And also, so how is the 12-month period measured? If there's 12 weeks you can take in a 12-month period, is it a calendar year or measured going forward or backward?
Yeah, great question. So the FMLA law allows employers for the job protection to choose one of the 4 options: the calendar year, any fixed period, looking back, or looking forward. For paid leave, anyone under the public program, we use the look back method. So rolling look back, basically, to determine that 12-month period of time.
Okay. And for the incapacity for the minimum days, your days off count too. You don't have to miss like 3 days from your employer. Say you became incapacitated on Saturday and Sunday, and you only missed 1 day of work, even though you might only get one paid for 1 day if you put in for it. It's still, those days off still count, correct?
Yes. So for the serious health condition and you're using the incapacity plus treatment
Right.
option, I think it's 3 consecutive calendar days. So it's based on the calendar, not necessarily the work days. So you're absolutely correct on that.
Okay, thank you.
You're welcome.
Hello, can you hear me all right?
Yes, we can hear you.
Okay. The new laws that went into effect as of January 1st, do they start on January 1st or do they go back? I heard a rumor that they're going back to the previous year. Is that accurate?
My understanding that they all would start on January 1st. There's some requirements that go into effect, I think July 1st. There might be like posting requirements for the employer they have to do by January 1st. There is one element that does factor in the past. The prior law for FMLA was, I think, 16 weeks of leave in a 24-month period, and it's becoming 12 weeks in a 12-month period. So because it kind of takes into account potentially that was taken prior to 2022, there is some rules about how leave taken last year might impact your leave available this year with that change in kind of the allowance in any given period of time. I don't know of any other circumstance where it would impact previous rules prior to January 1st of 2022. If you have a specific example, I'd be happy to look into it. I just don't know any off the top of my head that were retroactively effective.
Okay, the other question I had is the qualifying hours. Did I hear that correctly, that it went from 1,200 to 0?
Yes. So one of the changes.
What did I hear there?
One of the changes to FMLA, in Connecticut at least, is it's no longer an hours. Hours no longer required for eligibility. It's really about working for that employer for 3 months. So that specific employer, 3 months. It doesn't have to be consecutive. Just you have 3 months kind of service with that employer is eligibility for Connecticut FMLA.
Okay. All right, thank you.
You're very welcome. And I don't know whose hand was raised next. It was Michaela or Craig.
Craig can go
Michaela.
first.
Yeah, Michaela and then Craig. Yep.
Okay. So we have a number of grad workers at the University of Connecticut that we represent, and they work approximately 10 to 20 hours depending on their appointment in kind of a 9 to 10 month period. And I think one of the questions that we have is, it's seems like some of those workers may be eligible for Connecticut FMLA potentially, but not all. And then we are also a follow-up question is like, how does that impact the paid leave?
Yes, great question. I'm going to avoid a little bit of the FMLA. For that type of specific question, we might want to go directly to the Department of Labor to get their thoughts on it. I'm a little bit nervous because there might be assumptions that I make, and I don't want to give wrong information for that. As far as paid leave, I don't know of a reason why they wouldn't be covered under Connecticut paid leave. The state universities are covered employers. If they're unionized, they would not necessarily automatically be included in it because state employees who are unionized are not automatically included in paid leave, but they can opt into joining it. So if they happen to be unionized, maybe they're exempt for that reason, but they could opt into the program. I don't think there's any other exemption, unless for some reason it doesn't qualify as employment.
Yeah, it does qualify as employment. So yeah, they have like W-2s and stuff. So I think, yeah, that's definitely helpful. I think that answers some of our questions about like, it seems like the paid leave program is kind of separate from the FMLA, like Connecticut FMLA, and that you may not necessarily qualify for FMLA, but you could still get access to some of the paid leave. So that's a very helpful clarification.
Yeah, absolutely. I go back and forth as to whether there's more overlap than there is differences, or more differences than there's overlap, but there's definitely, you can fall into one and not the other very easily.
And if I could just interject to that too, Michael, I mean, we really are trying very hard to make sure that people understand that they are separate laws, right? So just applying for one doesn't mean that someone is applying for the other, because we have people who apply for paid leave and then they're surprised that they don't have job protection. So we really want to make it very clear that they are two separate things, even though they work so closely together. And I did just want to interject one other thing about the changes to, this is FMLA, so job protection. One of the changes that went into effect in Connecticut is that employers can, they can still require their employees to use their accrued paid time off to have income replacement while they're on leave, but they now have to allow them to retain up to 2 weeks. So previously they could make them exhaust all of that. Now they have to allow them to save 2 weeks of it for other purposes if they would like to do that. It's just something that I didn't mention when going through some of the different changes, and I wanted to make sure that that we said that.
Thank you, Jess. And I realize who I'm talking to now, the UAW. The fact that the people are unionized is much more common in this meeting, so I thought of it as a rare thing, but no, it makes very much sense if they were unionized. Craig, do you want to go next?
Actually, Jessica just answered one of my questions, but is there a difference? I know that I actually had a case very early on when the new law took place as far as your paid leave, that the employer had to allow them to keep 2 weeks of their time. But is that only vacation time, or is that PTO time? Because some of our employees don't have, they may have PTO time and vacation time, but they don't have more than 2 weeks. How does that apply?
It's a good question. It applies to your entire block of accruals. You know, you have to be able to keep at least 2 weeks of that.
Okay.
Depending on how it's structured, I mean, presumably they can't force you to use sick time if it's not about your own sickness or that's not covered under the employer's rules regarding sick time. So they shouldn't be using it to apply in situations it doesn't actually. For example, if they give you a week of bereavement leave, but your paid leave is not at all related to bereavement, they can't make you use the bereavement leave time unless the bereavement leave is part of a larger block that covers the same reason. So they can't force it if it's not part of what the leave is, the accrual is meant for, but generally they kind of all get it put into one bucket as far as what you're allowed to retain as far as 2 weeks of accruals. Does that help?
Yeah. And on that issue though, can an employee not apply for the paid leave? I've had that question come up to me. In other words, I don't want to utilize my vacation time before I can get the paid leave, and I'm only going to be out for X amount of weeks for an operation. Do I have to apply for that? Or because they're getting from some of the employers are telling them, oh no, you have to apply for the Connecticut paid leave if you're going to be out?
It's a fantastic question, and it's complicated. So nothing in the statute or the law requires you to apply for paid leave benefits. It's truly a voluntary choice on behalf of each individual employee. Now, where it becomes complicated is the other benefits may require you to apply for paid leave. I haven't seen it so much on the employer side, the benefits that employers run, but we do see it quite a bit now on the short-term disability plans that are maybe through a third-party insurer. And because that's a contract, there may be a contractual obligation in that insurance policy that says, we're either going to make you apply for any benefits you're eligible for, or we're going to reduce your benefit as if you did apply for it, even if you chose not to. So that's not really, it's not forcing you to do it, but the terms of that individual policy may kind of have consequences for your not applying to.
That was going to be my follow-up question to that, because that's another situation we've run across. It's amazing how many situations we run across in a very short period of time. And I guess the last thing, just for clarification though, if you are applying for FMLA, Connecticut FMLA, and you're also applying for this, the time frame does not extend. In other words, you can't take your paid leave without applying for FMLA so that you would get extended benefits. In other words, you would get to 12 weeks here, and then you can apply afterwards without paid leave for your total amount of FMLA.
I think I understand what your question is, so let me answer it, but then tell me if I totally misunderstood it. So the job protection and the paid leave, we really need to make sure that we treat those separately.
Absolutely.
So a lot of the times they're going to run concurrently. The first day you're absent, you're probably going to lose a day of FMLA entitlement. And then if you apply to us for that day, we're going to pay you for that day of paid leave. If you have accruals or something else that's stopping you from applying for paid leave, then your paid leave 12 weeks would not start running until you actually receive benefits from us. So if you hold on to that because you've got sick time you're using for 5 weeks, you'll have potentially 5 weeks that you've used of your FMLA time, leaving you 7 remaining, but you still haven't used any paid leave benefits at that point. You still have the full 12 weeks.
Okay.
Now, when you get to the end of that 12 weeks of potential job protection, you may still be entitled to paid leave benefits beyond that because you've only received, I forgot what my scenario was, 7 weeks of paid leave. At that point, you still have paid leave benefits available to you potentially, but you have to choose whether you want to continue to stay out of work and receive them and potentially lose your job because you may have lost your job protection for that. So they may run concurrently. You may take one after the other or kind of stagger the amount, but since what they're giving you is different, there isn't sort of a stacking of either benefit.
Yeah. And I've advised a couple of people that have asked me that you got to remember, if you're not applying for the FMLA, then you don't have job protection. And I don't want you, taking the paid leave and then coming back and saying you lost your job because the employer, you weren't protected under it. So, but okay, that answers my questions.
Absolutely. And
my members' questions that are asking me that, I wasn't sure. So thank you very much. This has been very informative.
You're very welcome. Eric, do you want to go?
Good morning.
Good morning.
My question is, do we have to use the CTPL
Did I lose connection?
versus our contractual paid time off? But the insurance company has told 2 of my individuals that they would have to apply for the CTPL leave first.
And I apologize, Eric. You may have gotten cut off, might have just been my headset. So the question was, if you're required to apply to paid leave because of an insurance policy?
So we have contractual benefits that pay us 100% of our salary for the first 13 weeks out for any medical condition, for short-term disability. The insurance company that holds the policy is telling my guys at the shop that they have to apply for the CT paid leave first.
Yeah, so that's going to really be dependent on what the actual insurance policy says, or what the collective bargaining agreement says as far as what you're required to do. Connecticut paid leave doesn't require you to apply for benefits through us, and the law for Connecticut paid leave doesn't require that, but it's possible the insurance policy does. Generally, that has been acceptable. If there's some concerns that there's something going wrong, they are applying a rule that doesn't actually apply isn't actually written in the policy. You may want to talk to the Department of Insurance if there's any sort of worries about inappropriate behavior on the insurance policy side. But generally, it is allowed for a contract to require you to apply for CTPL, or to treat you as if you had applied for it even when you didn't, because they often treat themselves as the payer of last resort. You kind of have to exhaust all your other options, and then they'll pay. That's somewhat common in short-term disability plans for employers.
Okay, thank you.
You're welcome. And Craig, your hand is still raised. Are you?
Oh no, I'm sorry. I didn't take it down. I apologize.
No problem at all. One thing that Jose, I see you have your hand raised.
Okay, can you hear me all right?
Yes.
Okay, so I think we have a similar situation as Eric had. We had people who were told to apply for the Connecticut paid, and they also applied for short-term disability. The short-term disability is only paying a minimal amount, whatever is due, because we also get 100% short-term disability. So if the paid FMLA is paying, let's say they're getting 800 a week, it's paying 600 a week. The insurance company is only giving up a check for 200 a week. And it's taking quite a while to get the paid FMLA. So we have individuals who are out for 4, 5, 6 weeks and haven't gotten a paycheck from the state, and they're trying to, pay their mortgage and everything else on the little amount that the insurance company gives. Is there any way that the insurance company would pay this full amount and then Connecticut Paid Leave would reimburse them? Or is there another avenue here to get our folks paid quicker?
Yeah, it's a good question. First of all, we agree. There's some delays that are truly our fault. There's a huge spike in claims we received, particularly in the end of January and February, related a lot to the Omicron variant of COVID. So we just had more claims than we were prepared to deal with, and we're still climbing out of the backlog. We're getting better at it. We're responding to claims and hopefully paying people a lot faster than that. So I agree. We certainly have unacceptable delays in the past regarding the paid leave claims. I think we should be getting better about that. And then sometimes it's caused by confusion about what the employee has already done. They gave their documents to the insurance carrier or their employer and didn't give everything to us. So sometimes that's causing confusion. We're going to do a lot better about communicating that and making sure everyone's aware of exactly what benefits you're applying for at the time. So I'm hopeful that we've seen the worst of this so far and that everything's going to be smooth. That said, nothing would stop. It's sort of up to the insurance carrier if they want to kind of pay the full amount up front and then tell the employee they've been, they can pay them back when they finally get paid leave. That's kind of up to the insurance carrier if they're willing to do that. We're not prepared to pay anyone other than the employee. We're not at this time ready to reimburse anybody. We kind of have to kind of keep the payment going to employees. We don't know if we're ever going to be able to do that. We can obviously look into it. We're so young. We don't want to add more confusion and more difficulty in making sure we're paying claims appropriately. So we're not in a position now, but obviously we can take that back. Finally, the best resource might be to talk to I don't know where the employer fits in this situation, whose side they're sort of on between the employee and the insurance carrier, but sometimes it's a matter of talking to your employer, having the employer talk to the insurance carrier, and making an arrangement for what works best for them. Obviously, some insurers think of the employer more as their customer than the individual employees, because they're the more powerful entity who makes a lot of the big decisions. So sometimes a compromise can be worked out exactly the best arrangement for who pays what, when, and avoiding someone having to go weeks at a time without receiving any benefit, or one person assuming that the other person's paying when they haven't yet approved that claim.
Yeah, and the answer we got to that question was that it's out of their hands. It's up to the insurance company and the state. So, but okay, I understand.
Yeah, I've got no power over this, but there's also the idea of the insurance carriers paying less. Maybe there's an opportunity to renegotiate the plan in light of now there's a new benefit that they're receiving, which meant the claim payout on the insurance carrier side is smaller. Maybe its rates go down. Maybe it's shopping around for a new carrier. There may be levers that could be pulled that kind of convince them to renegotiate or reconsider what's going on with some of the claims. But ultimately, we have no power over that. It's a lot of it's just a contractual negotiation between the carrier, the employer, and the employees. Thank you. Jose.
Yes, I think, most of the biggest complaints that we've gotten is, in negotiations, some of the issues that we've had is the job protection and paid leave some employers have tried to negotiate for it to run concur. Obviously, people would not have job protection after a certain amount of time. But then the next biggest issue is the one that Eric mentioned, where a lot of these insurance policies are coming back telling the employees that they must apply first for paid FMLA. So, now we do know that we're going to have to go back and verify the policies to see what the policy says, to see if that's correct. And you're right, there is an opportunity to negotiate with them because they having big savings right now. These insurance policies and the employer, they having big savings with the paid paid FMLA here in Connecticut now. So we're going to have to go back and, at negotiations, try to have a conversations with the employer and see if we could renegotiate a different plan that covers more, or, figure out a way to get a little more for the money that they paying. So.
Yes, absolutely. A lot of these plans, I don't know how long it's been since the rates were kind of locked in. But if you're talking about negotiations that happened in 2019, 2018, or that's only 3 years ago now, that was before paid leave existed. It was even, in a lot of people's mind that it was a concept. So, that as a potential reduction in how much the insurance policy would have to pay may not have been part of the thought process. They thought about Social Security disability and some things like that are, were more common at the time. Now with paid leave in Connecticut or rolling out in other states, it's brand new. It may not be in bad faith that they were negotiating for those rates, but now that paid leave is here, it's real, there's benefits that are available and potentially reductions to the insurance policy, it only makes sense that it should be a kind of renewed conversation about what that means for either the rates or the policy plan details.
How do you see the process with, what Eric mentioned, that there's people who haven't gotten the benefit because of, how long it's taken? Is that something that's eventually going to get worked out, or we're just trying to figure out how long this is going to go on before it kind of settles?
Yeah, it's a great question. I can't provide a specific answer that, by June 1st, we'll have everything worked out. I think the backlog has shrunk significantly. That was caused by the January, February influx of COVID claims. So we think that that's going to be less of an issue, probably end of this month, beginning of next month. But there are delays for other reasons. Jessica mentioned some of the documents that are needed for some of the claims. So, you as an employee may do your part and submit, your request, your statement of familiar relationship, or whatever the documents that you need to kind of complete and provide. But there still is, the employer has to fill out a form. Possibly if it's a medical condition, serious health condition, your doctor has to fill out a form and send it to us. Some of the delays are caused by things like that. And, until we get that documentation back, there's nothing really we can do. We can't approve a form or approve a claim without kind of the necessary proof. So sometimes it's a matter of, talking with your employer. Have you gotten that form yet? Talking to your doctor, hey, can you send that in, by Friday? Some of it, obviously light pushing on the responsible parties to get the documents back, that could help. And then if it's truly someone's being obstinate, your employer just says, I refuse to fill out this form, come talk to us. We have some levers we can pull involving subpoena power that we can use if it's truly an employer who's deciding they don't want to help you on this situation. We haven't experienced that yet on any claims, at least none that I'm aware of. It's usually they don't know what they're doing and they don't know who's supposed to fill it out. You gave your form to your boss. That boss doesn't know if they can fill it out. They don't know if they have to go to HR. Their leave management is outsourced to some third party that they have to go to for documentation. And it's a lot of it's confusion that's causing delays, not truly bad faith behavior. So I think as employers become more comfortable and more used to the process, that's going to help as well. So it's a lot of different reasons. Each reason can have a different solution. But I think I think we've seen the worst of it so far as delays in getting payments out there.
And Jose, you can feel free to, if you want to connect people with me, I can help as well. If there's, if they've placed a couple of calls and they haven't heard back from AFLAC, or because sometimes they don't even know that their employer, what I've been seeing is a lot of employers not filling out the form properly. And then the employee doesn't necessarily know that. And they may call and reach out and see. We've also had medical certification forms that the doctor just didn't even sign, didn't like put the proper dates, and sent along the form or sent it to the wrong place. It's been a lot of different reasons, but I'm happy to help. And you have my email address, so feel free to forward people on to me that I can help them navigate and see what answers I can find out.
Thank you, Jack.
Yeah, of course.
I just wanted to add to that, on that note of what Michael and Jacqueline were just talking about. We are working on a lot of different educational materials just to alert employees to some of these different things. So to make sure that they know to check over the medical certification when their doctor gives it back, and make sure that the doctor actually put a start and end date. One thing we're seeing is doctors putting end date of leave to be determined. Well, we can't have that. It has to have an actual end date, even if it's an estimate that might change. So we're just working really hard to make sure that the employees know, so that they can sort of double check some of those forms that other parties are filling out for them. Same thing with the employment verification form, just making sure that they, like Michael and Jacqueline mentioned, hey, by the way, have you had a chance to fill out that form? If you haven't been able to send it back, do you want to give it to me and I'll get it back for you, just to kind of help move the process along, because we don't want people to feel like they've gotten in all their paperwork and they're just waiting, but actually their file's not complete yet.
And I see Paulo has his hand raised.
Good morning, everyone. I just wanted to, can you hear me?
Yes, absolutely.
Sorry, okay. I just wanted to know, if you get denied for any reason, do you guys give a reason for the denial?
Yes. So any denials, you should get a letter within writing with the actual reason for the denial. It should also include the right to request a reconsideration from AFLAC. You can submit a request to have a different person look at the claim and see if it was actually truly supposed to be denied. And then also, I think Jessica mentioned the Department of Labor appeals process, how to submit an appeal to the DOL if either your reconsideration was denied or you don't want to go through the reconsideration process. So all of that will be in a letter. Also, it's possible, because the letter may take time to get to you, if you call and check the status, they may tell you as well that it's denied, but you'll always get that in writing along with the reason for the denial.
Thank you.
You're welcome. One thing that is actually, I think it might have been Craig's question about the stacking of benefits that I just wanted to kind of, he wasn't part of his question, but maybe it'll be helpful information. Jessica mentioned eligibility for the program. It applies up through 12 weeks after the last date you were employed with a covered employer. So if there's a situation where your FMLA job protection maybe runs out prior to you ever having requested paid benefits, it's possible you could be terminated at the end of that job protection and then still have 12 weeks before you file a claim for paid leave benefits. So, it's hopefully a really generous period of time that you have to begin your claim and kind of when you need to request benefits based on other income you may have, whether it's employee accruals, short-term disability policies, or anything else that might be available to you. So, sometimes even when you lose a job protection and you still haven't filed a CTPL claim, you still might be entitled to benefits from us.
Okay. I think that may be it. I put my email address in the chat. If y'all want to write it down, I'm happy. Feel free to send on any additional questions, or if you have any members that may be having an issue that needs some help. Again, we're really happy to help and navigate everything. And I'll send the slides to you, Jose, so that you can distribute. And I can also send a recording as well if you're interested, like if you think members would find that helpful.
Yes, Jackie, thank you so much. And also Jessica and Michael, this was really, really helpful.
Oh,
So yeah, definitely we would appreciate the slideshow presentation and the video, and you know, so we could go back and if we have any additional questions, obviously we'll go ahead and email you.
Yep.
Just to clarify, but we really appreciate this.
Yeah, no, this is great. No, we're happy to do it. So don't hesitate to get in touch.
Thank you.
All right.
Thanks for having us.
Yes.
Thank you, everybody.
Thank you. Have a good day, everyone. Take care.
Thank you. Have a great day. Thank you.
Okay. Bye.